Your Honor, I apologize. Just took a minute to get in, and
It's okay.
I would like to reserve 5 minutes, please.
All right.
May it please the court, my name is John Goldsmith, and I represent the appellant Linda Margoudakis, formerly known as Linda Lumpos. There is one issue in this appeal, and that is under the express language of Florida Statute 655.791. Is an account a tenancy by entirety account when it is first opened only in the name of one spouse and the other spouse is added to the account later with the express designation that it is a tenancy by entirety account?
Mr. Goldsmith, is it your position that the statute abrogates the common law?
Yes, it is. And that is what the Story Mountain case and the Versace case both held. And because in this case, Peter Margoudakis opened the account of Raymond James in his name only in February 2017, and 7 months later added his judgment debtor wife, Linda Margoudakis, to the account. And in the account signature card, the account is named Peter E. Margoudakis and Linda L. Margoudakis, TEN/BY/ENT, and they also checked the box in the signature card under registration stating, quote, tenancy by entireties, close quotes. After that time, all of the account statements after that date stated the account the same way that it was listed, which is Peter E. Margoudakis and Linda L. Margoudakis, TEN by ENT. Now,
Mr. President,
yes, go ahead.
to sort of follow up on what Judge LaRose asked, is it your position then that the amendment to the statute went beyond what the Florida Supreme Court requested in Beal, which was, I believe, essentially just to clarify the change in the burden of proof?
That is exactly what I'm saying. And the statutory language is clear and unequivocal, because what the statutory language says is changing the common law for the requirement of the 6 unities, and that's what Versace and Story Mountain both hold. Because what the statute says is clear and unequivocal. 655.791 provides, and I quote, any deposit or account made in the name of 2 or more persons who are husband and wife shall be considered a tenancy by entirety unless otherwise specified in writing. And that's about as clear as it can get. The only unity that is now required is the unity of marriage.
Well, let's stop, because take a look at the use of the word made. What is the significance of that word in context? Because it seems to me that if the unity of time were no longer necessary, then the sentence would just say any deposit or account in the name of 2 persons who are husband and wife. And that would certainly convey the same thing. So what is the significance of the inclusion of the word made? Because to me, that can alter the meaning of that sentence.
Yeah, and that's a good question. And that is what and that is what, at least in dicta, some bankruptcy cases have held prior to the decisions in Versace and Story Mountain, which hold that those unities are no longer present. But the language doesn't say any deposit or account first made in the name of 2 persons. It says made. So the question is, when is an account made? It doesn't say when it's first made. When is it made? Well, an account is made, and this is what the Versace court said, an account is made when if you change the title of the account to tenancy and you add a person and you say tenancy by entirety, then that's when that account is made. But it not only says account, it says any deposit. So what does it mean when it says any deposit made in the name of two persons? So that would mean that that would at a minimum mean all deposits made after the account was changed in 2017. But what's important, I think, is that the language does not use the word first made, it uses the word made. And I think Versace and Story Mountain make clear that the entire reason for this is to bring clarity and certainty and to prevent the type of requirements that occurred in the common law, where the only way you could establish a tenancy by entirety account, you had to literally close the account. And in one case, they said you couldn't even open the account in the same bank. And it was to get rid of that kind of formality. You have to close the account and you haven't had to open a new account. And what the statute is doing is the statute is eliminating that type of requirement. And if I can quote from the Story Mountain case at page 713, the court said, instead, as this court recognized in Versace, which was decided after the trial court ruled in this case, the legislature went a step further and codified that all joint spousal accounts are now tenancy by entireties, quote, as a matter of statutory law, and they're quoting the Versace case, regardless of the presence or absence of the common law requirement of unities, close quotes, and in the absence of an express designation otherwise. And then the Story Mountain court, which was a decision earlier this year, goes on to say that is the plain language of the 2008 amendment to section 655.791, eliminated the requirement previously set forth in Beal Bank as an aspect of the common law presumption that the unities in the formation of account be present. Now, all spousal bank accounts are considered as held by tenants by the entirety unless otherwise specified in writing, and no one need establish all the common law unities in those instances where a third-party debtor seeks to garner such an account. So
Mr. Goldsmith, what do you say to Mr. Miller's suggestion that eliminating the unity, the tenancy, the elements is going to lead to all sorts of mischief?
Well, and the only mischief that Mr. Miller states is that there will be mischief because you could simply title an account Joe Smith and Mary Jones tenancy by entirety, and if they're not married, it would just be tenancy by entireties. But the statute specifically says that it only applies to husband and wife, and that's the only.
That scenario, that possibility would exist even if we apply the common law, correct?
That scenario, well, that scenario that Mr. Miller states would, I think, would not be present if the common law was there, because under the common law you would have to show that the parties were married, and you still have to show that they are married under 675.791. So I think to that extent, that requirement is still present by the express language of the statute that says it only applies to a husband and wife. But there's no other absurd results that Mr. Miller has suggested or that I can think would be present under this circumstance. What is eliminated is the absurd result that you have to actually close an account and then open a new account in order to establish a tenancy by entirety. And that's simply not what the clear language of the statute provides. And this is, the language is clear and unequivocal as found by both Versace and Story Mountain, and Versace is directly on point.
Well, in Versace, I mean, I'm a little confused at some of the discussion because it seems like, or maybe I misheard you, that you're taking the position that the statute did something that Beale didn't require, but Versace says the opposite. Versace says the statute just reinforced what Beale already said, which is if the signature card contains the designation of entireties, that ends the inquiry.
That's correct, Your Honor. And if I miss,
so that's what they said in
that.
Versace. And that the statute just simply reinforces that.
That is what Versace says, but in addition,
right, but am I hearing you that you think the statute did something different?
No, the statute did do that, but in addition to that, what Versace and Story Mountain said is that it eliminated the other unities that used to be required.
Well, yeah, Versace says Beale eliminated it because it says Beale didn't ended the inquiry if the signature card contained the designation. You have the inquiry if it didn't have the designation. I mean, that's how Versace read Beale Bank.
That is how Versace read Beale Bank. Story Mountain goes a little bit further and simply says all of the unities are eliminated. And,
well, I think I put my money on Versace before I put it on Story Mountain.
Okay, but my point is that Versace says that quotes Beale Bank and says if the account designates how that it's tenancy by entirety, that ends the inquiry, and then says that the statutory change 675.791 codifies that change. And reinforced is the word, or reinforces that. Yes,
right.
And that's exactly, I think, what's present here. The Versace case and this case are not distinguishable. Obviously, this court has the ability to reevaluate that, but again, there are important practical reasons why this was done, and why.
Mr. Goldsmith,
yes.
Did it eliminate the unities with respect to a joint tenancy with right of survivorship?
According to Story Mountain, it did. It did say that was no longer required. Now,
it would have to, right? I mean, it would have to just basically do away with the unities in both situations because the characteristics of both types of accounts are identical. Correct?
That's correct. And the language of the statute is clear. The language of the statute doesn't say anything about the unities. And this was the Florida business law section. When this came up, the whole purpose was to provide certainty and clarity as to these accounts, and to get away from the kind of common law technicalities and formalities that developed under a confusing web of cases that were decided.
But the confusion arose out of determining whether you had a joint tenancy with right of survivorship or a tenancy by the entirety. Correct? I mean, wasn't the confusion as between those two forms because the characteristics were identical, but the consequences were very different?
That's where most of the case law came in, Your Honor. That's correct.
So you were already functioning within that sort of closed universe of as between these two accounts, which both have these 6 unities, which one are we dealing with here? That was Beale's concern, right? How do we resolve that confusion? Who has the burden of resolving that confusion?
That's right.
It was not this broader world of, well, we have an account involving married people. What type of account is it? It was narrowed to between these two types of accounts.
That's correct. Although Beal Mountain, or excuse me, although Beal Bank was dealing with that distinction, that's absolutely true. But also, much of Beal Bank is discussing the need to clarify accounts when it comes to joint tenancy by entirety, and that's what 655.791 does.
Mr. Goldsmith,
But-
you're at your 15 minutes. You're free to
Thank
use
you.
it however you like.
Yes, I will reserve the remainder of my time.
Okay. Mr. Miller, whenever you're ready, sir.
Good morning, Your Honors, and may it please the court. I'm Aaron Miller on behalf of Appellee Dove Investment Corp., who is a post-judgment assignee to the original judgment creditor. As counsel had pointed out, we are here on a very minute issue concerning the method of establishing a bank account owned as tenants by the entireties. I don't believe there are any material facts in dispute. The bank account was originally opened by Appellee's spouse, and appellant was added as a joint owner sometime after the account was created.
Mr. Miller, help me understand some of it. Let's go back to Beal. And I read that as, in the first instance, a way to take care of what seems an apparent this different treatment between real property and personal property.
Yes. Yes.
And
Beal-
then once it resolves that disparity of treatment, it suggests to the legislature that it may wish to do something that perhaps creates some sort of rebuttable presumptions about these unities. Is that fair?
Yes, Judge. When it comes to the history of creating entireties assets, historically there were those 6 requirements, the unities as they're referred to, which were the unities of possession, requiring the joint ownership and control, unity of interest, that the interest be identical in that asset, unity of title, that the interest must have sprung from the same instrument, and the unity of time, that the interests must have begun simultaneously, along with the unities of survivorship and marriage. In older
I understand the unities, but it strikes me that the legislature, you would agree, the legislature went far beyond what the Florida Supreme Court had suggested as a fix.
Well, as Your Honor pointed out, there is this difference in treatment between real property and personal property. With real property, in 1947, the legislature created a method that a married couple could directly convey property to each other as spouses and create an entirety's estate, eliminating the need for employing a straw man when a spouse wanted to own a formerly solely owned asset with his or her spouse. This was Florida Statute 689.11. My understanding of Beal Bank, as analyzed by numerous of the authorities that we had cited to in our brief, had to do with an ambiguity in various types of signature cards that were being used by financial institutions, where you wouldn't necessarily have that list of options for different types of ownership on a bank account. There's nothing out there that says a married couple has to own an account as tenants by the entireties. They could own it as tenants in common. They could own it as joint tenants with rights of survivorship. And Beal Bank attempted to sort of clarify that ambiguity and to raise this presumption that if the signature card is silent as to the type of ownership that was selected by the presumably by the spouses when the account was opened, so that there would be some sort of clarity when the signature card is silent as to the specific type of ownership that was being selected.
But then it seems to me the legislature took it a step further. And if I open an account, or I have an account and I add my spouse and call it, tenancies by the entirety, end of discussion. no presumptions, no looking at the unities. You know, is that I take it you don't think that's a fair reading of the statute?
No, not as to the statute. Now, the presumption raised in Beal. Now, Beal also states that the owner's interests in the property still must be identical, and the interest must have originated in the identical conveyance, and the interest must have commenced simultaneously. 655.79, I think was, and this was, I'm taking this from the cases that we had cited to, seemed to attempt to clarify or provide a statutory, I don't want to say mechanism, but a clarification that if the signature card is silent, then we don't have to worry about interpreting the terms, any boxes that were checked, any notations on a signature card as to whether or not an account would be owned as tenants by the entireties. Now, in this case, the fact is not in dispute that the subsequent signature card does have the handwritten notation, or it's written in to be joint tenants. I'm sorry, not joint tenants, tenants by the entireties. However, our position is that an account that was never a tenants by the entireties account cannot be converted into a TBE account simply by adding a spouse, regardless of what the subsequent signature card would say.
That position strikes me makes a lot of work for the financial institution. It makes a lot of work for the couple that are trying to manage their financial affairs.
Quite possibly, and candidly, it is our position that the state of the law is, if a married couple wishes to own an account as tenants by the entireties, they do have to close an account and open a new one, and have all of those unities present when the account is open.
So it would be fair to say you disagree with the Versace case?
Yes,
it's wrongly decided.
I don't want to say flat out that it's wrongly decided. I would rather say a little bit more artfully that it may have been the product of, I don't know, I don't want to say maybe misinformation or incomplete briefing. I've reviewed the briefs that were submitted in Versace, and there is a lot of the authority that we had presented in our brief that was not presented to the 4th DCA when it made its decision in Versace. For instance, in Versace, none of the briefs refer to the cases of Benzaquin, McQuan.
Are those the bankruptcy cases?
Yes, Judge. Benzaquin and McQuan are bankruptcy cases. However, McQuan was from the Middle District of Florida.
Are those the ones that turned on the notion that the word "made" in the statute has some significance?
Yes, Judge. And McQuan
Okay.
was actually an appeal from a bankruptcy order to the Middle District.
Let me ask you about that, Mr. Miller, am I interrupting you, Judge Kelly, in your training?
No, I'm good. Thank you.
So let's look at the word "made," because earlier in the statute, the legislature uses the word, in connection with the opening of an account. So obviously the legislature knew about the existence of the word "open." And if they had meant when the account is open in the last sentence, couldn't they have just used that word again, as opposed to using the seemingly broader word "made"?
They could have. I don't want to try to speculate as to what was in the mind of the legislature, but I believe.
Well, don't we have to at least acknowledge that that's a broader term, and it's a term that could include Mr. Goldsmith's position that that account, it was made in the names of two people when they went in and put the second name on it.
Well, I think a plain meaning of the word "made" would not permit such an expansive view, because the legislature used the word "made," not an account already in existence. Additionally, as we had
But,
brought up.
but could made mean the actions of the married couple? They made it an account in two names as opposed to making the account?
It's possible to interpret that. I would say that if something is made, that is the point in time in which it comes into existence.
Right.
Well,
but
you
what I'm
know,
saying-
open is when it comes into existence, and they had to come up with if they didn't mean open, they had to find another word to put in there. And I mean, so I think you could make the argument if they didn't mean open because they didn't use that word, they found a different word, and the word they found was made. I mean, there has to be some word there, and they didn't choose open.
Yes, but again, to say when something is made implies when something is created.
Well, what word could they use if what they meant was you can add someone later? Well, I mean, what word would you suggest would fit there if they didn't mean open and made means open, but that's not what they want to say? What word would you suggest?
Either, well, in connection with a bank account, it could be something like converted, added. I'm going
But
through
that excludes the people that did open it together, because you need a word that encompasses not only people that opened it together, but people that were added at a later time.
Yes, Judge. Well, now
I know I'm giving you an impossible question, but I mean, I think if you want to say there's some significance to that word, I think it's fair to explore that.
Yes, and I believe the numerous of the cases that we had cited to, they do go into an analysis of the use of the word made, and routinely and uniformly, with the exception of, I guess, Versace, which did not include a review of these cases, but the cases that did analyze the use of the term made uniformly interpret that to mean the point in time when the account was opened. Now, the legislature is aware of this issue, as we had pointed out in our brief and included in the appendix there too. The attempt by the Florida legislature to codify an abrogation of the required unities of time and title.
Well, I did see your argument in reference to that, and you included that, but I think under the supremacy of text regime that we now operate under, we look at the words of the statute and we can't be concerned with what some staff analysis said, because what was ultimately put into law by the legislature is what we have to be concerned with. And I understand why you would look at that and want us to find it persuasive, but I'm not sure that we really can look at it. I mean, how can we go and look at a legislative staff analysis to tell us how we should decide this as opposed to just the words of the statute?
Well, not necessarily the staff analysis, but the entire process of that proposed legislation. A look at what the legislation was to enact, which would have been a new statute, 689.151. And in that proposed language of that statute, which would have been sub 2, would have expressly abolished the common law requirements of the unities of time and title. That the legislature chose not to enact that statute indicates its awareness of the issue, its awareness of its ability to augment or abrogate the required common law unities of time and title, and that by choosing not to enact that legislation, it's a tacit approval of the current state of the law.
Or it could mean that they became convinced that they didn't need to because it had already been abrogated.
It could, however, at the time, all of the case law in existence that discussed the topic would be to the negative of that point, that it had not abrogated the required unities of time and title, and that it still was necessary for the account to be opened with all of the required unities in place. I hope that answers the question. I don't
Yeah,
know.
yes, thank you.
And so while it is merely a proposed legislation, I just want one more point on the that proposed legislation. While it was merely proposed legislation, there was staff analysis. I would posit to this court that it is most certainly something that can be looked at. It can be considered persuasive, while it may not be binding, but it definitely does indicate the knowledge and awareness of the legislature in its ability to change the common law when it comes to tenants by the entirety's assets. Another example of that would have been 689.11, which was, I believe, originally enacted by the legislature in 1947. It created a shortcut for only with real property, but it did create a shortcut for an asset that had been solely owned by one spouse to be converted into an entirety's asset simply by deeding the property from the owning spouse to both spouses as a married couple. That is another example of the legislature showing its knowledge of the common law and its ability to create the mechanisms for creating or abrogating the common law unity requirements to allow for the shortcuts, to allow for the more convenient method of spouses having and maintaining entirety's assets. And in this case, with bank accounts, there is no such statutory language. There's no statute out there regarding personal property or bank accounts that comes anywhere close to 689.11. The language of 655.79, it just doesn't go that far. And in relation to real property, it is very clear, it is very unambiguous, the steps necessary for one spouse to add his or her spouse to title to real property and then create that entirety's estate in that real property. And there's nothing in Beal, again, as I had mentioned, that abrogated the required unities. In fact, Beal Bank from the Supreme Court flat out said that you still had to have the unities when the account was open. In the instant case.
Well, I don't think anybody's disagreeing with that. I think we're all sort of, certainly your opposing counsel position is we're beyond Beal. The legislature has gone beyond that. So we are looking at the statute and whatever Beal may have said or wanted or tried to accomplish, that we're way past that at this point. So I don't think anyone disagrees with you on that.
Okay, yes, thank you. And so I guess then focusing back to 655.79, there, while it does use the term, when an account is made, we had presented fairly substantial authority that the interpretation of that clause indicates or goes back to when an account is opened, not subsequently adding a spouse to an account to then create an entirety's account. And the cases that we had cited to, candidly, they are from the sister courts in the federal system. Because, and candidly, that it just hadn't been a topic for which there had been lots of opinions within the Florida District Courts of Appeals until I think Versace came around. That might have been the first. But all of the cases coming out of the federal system, as well as the legislative analysis and the proposed legislation, seem to be very clear. And the cases that we cited from the federal court system are also directly on point, where one spouse had opened an account and later added his or her spouse to that account. And all of those courts uniformly found that an entirety's account had not been created. I would also like to just touch very briefly on the arguments raised in the initial brief as to the end of inquiry when reviewing a signature card in connection with a spousely joint owned bank account. I believe there might have been a little confusion in our argument, as raised in the reply brief, that we thought or had argued that such application would result in some sort of absurdities. Our position had to do with situations where, just because a signature card says something, while it may be of great weight, it is not the end all and be all, and cannot be the end all and be all of any sort of inquiry as to whether an account is an entirety's account. And I believe the examples that we had provided in our answer brief were, just because two people check a box that an account is tenants by the entireties, it still means, it doesn't mean that they don't have to still adhere to the 6 unities. They would still have to be married. You could not have a situation where a husband opens an account, doesn't actually list the wife as a joint owner of that account, checking the box as tenants by the entireties. That still also would not or should not create an entirety's account. That is the absurdity that we had referred to and sought to avoid in any opinion that may come from this action. And so, I think I'm just going to end there. I don't think I have any more points to make. And so, in conclusion, I would say this court should not ascribe to the argument or the shifting of the use of the term "made" as found in Versace, that the common law requirements of the unities of time and title have been abolished. It seems that in Versace, by just judicial opinion, the common law regarding the creation of entirety's assets has now somehow been abrogated. However, the case law that we had presented, which was also directly on point in analyzing 655-79, Beal, and the required unities, all uniformly stated that you can't just add a spouse to an account and convert it to an entirety's account. Additionally,
okay. Thank you, Mr. Miller. You're at the end of your time.
Thank you, Your Honor.
Wrap up. Okay, thank you. Mr. Goldsmith, you've got 4 minutes.
Okay, great, Your Honor. And I want to make just a few points. First, I think, Your Honor, Judge Kelly, that your point is really kind of dispositive, to the extent that the last sentence of the statute 655.791 is not unequivocally clear on its own. If you do any statutory construction, then you look at that same statute in the first sentence of the statute, which refers to the opening, which uses the word opening of the account, and they could have used that word opening if that's what they intended. Secondly, with regard to the 2019 legislative history of a bill that was never passed, that was legislative history to essentially apply the statutory change in 655.791 from accounts to all personal property. And the legislative history says that that's what this bill does, is that it applies 655.791 and eliminates the unities of title as to all personal property, not just accounts. And I think that's really the key issue. The last thing is, all of the federal cases that they've cited, none of those cases, in the opinion, actually state that the account is titled tenancy by entireties. They all have different titles, or the opinion doesn't state how it's titled. And that's really the one of the central issues here, is that our account is specifically titled tenancy by entireties in 2 different places, and that under the Versace case, under 655.791 and under Beal Bank, that is dispositive. So as a result of that, we would respectfully ask that the court reverse the county court's decision on the finding that this account is not a tenancy by entirety account.
Okay, thank you. Thank you both. All right, our next case this morning,
Thank you, Your Honors.
thank you both.